Hey, hey. Hey. My little parka wearing, freezing, shivering, barely getting through the hypothermia. I'm just kidding. It is cold outside. I'm dying. I hate winter. Duh. Thank you for coming, everybody. Thanks, everybody. Welcome in. And thank you for being here on time. I appreciate you so much. So here's what's up. Before I forget to tell you, I pinned this. Thursday morning, Daryl Brooks is going into his pretrial. I don't know if they're going to show anything. Y'all know we do this every time. We're going to be there if he's there. We're going to be there. Let me tell you what time it was. Hang on, I'm trying to find my notes. 9 a.m. Central. So 9 a.m. Central time. We're going to go live. I think it's this. My stream starts at 8:45 a.m. If regardless of whether they show his trial for Erica's case, we're still going to be streaming some clips and stuff. So if you can, if you're available, please plan to join us. Go ahead and go on there and click that notification button, and the link to it is in the chat. Okay, let's get on to Suitcase Sarah. So did you forget she had a little update this morning? She was supposed to be in trial. Well, no worries. Apparently the judge forgot to. But you guys, you didn't miss anything. So here, let's watch.
03, State.
Dave.
State of Florida versus Sarah Boone, 2020 CF 2603, State.
Dave Cacciatore on behalf of the state.
Mr. Cacciatore, good morning. The court was just made aware that a motion to continue waiver of presence was filed on January 12th, 2024 at 11:18 a.m. A copy of it was not favored to my office. My judicial assistant found it this morning by scouring the record once we did a call in the halls for counsel for Ms. Boone. The motion reflects that additional time is needed in order to prepare this case for trial. Counsel is still reviewing extensive discovery in this case and is also seeking appointment of experts with the S in parentheses. This court has approved costs for a private investigator. The task to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. Reflects that speedy's been waived and that you had no objection to same. Is that accurate with regard to your objection or lack thereof?
That is, and I've had the chance to review that motion, Your Honor.
I'm sorry, Mr. Cacciatore, say again, sir?
That is accurate, and I have reviewed defense's motion to continue.
Okay. The motion does not identify the amount of time that they're seeking a continuance. In your conversation with Counsel Hobson, are you in a position to advise the court as to how long of a continuance they're seeking? Oh, no, the wherefore clause says 3 dockets. I apologize. Any objection to that, sir?
No, Your Honor.
Okay. The motion to continue will be granted. This matter will be continued for 3 dockets. Now, my understanding is that this is typically specially set. So do we want to have this especially set at a certain time, Mr. Cacciatore?
I think that would probably be better. Typically, Ms. Boone is elected to attend many of these hearings and not waive her appearance at them. So I also think too that we're at the point that we're close to being I think ready for trial, and that I guess without getting into too much more without Mr. Hobson here, yes, I think just we could set it for a special set status.
All right, the court has availability for a special set on May the 3rd at 9 a.m. The court's inclined to have this as a special or as a final continuance due to the age of the case and the motion not specifying anything more than a 3 docket continuance.
That's acceptable.
Okay, all right, we'll set this matter for a special pretrial on May the 3rd at 9 a.m. Ms. Boone we'll have a mandatory appearance for Ms. Boone at the May 3rd at 9 a.m. pretrial. What's the the following trial period for that?
The trial period for May the 3rd would be May 13th.
So there you have it. May 13th is when they've now rescheduled her trial. Y'all, this is the 13th time they've had to reschedule her trial. And why? Why? Because the hussy can't quit writing letters and bad-mouthing her attorneys. How many attorneys? Is she on attorney 7? I think it's number 7. Yeah. So what we thought that she was going to be going to trial in January the 29th of this month. I was all ready to stream it. No, it's been pushed back to May. That's so far away that I can't even tell what we're going to be doing at that point. There could be something else that comes up that's even bigger and better. Who knows? Probably not, but I'm just saying. Anyway, so that's the status on Sarah. Everybody was saying it was going to get pushed back, but I just cannot. I just cannot. So anyway, that's what we find there. Now, as you guys know, Sarah's. I gotta stop reading the chat. Y'all distract me. As you guys know, Sarah's trial is pretty much based upon domestic abuse. It is a very sticky topic. I don't know why it's so sticky. It's so common. It's very tragic, and I thought the best thing to do would bring up our next issue with Judge Tammi on the same topic. And let me tell you, she gets heated over this case. Judge Tammi does. So watch along with me.
All right. So, Mr. McGeechee, you're before the court on State of Georgia versus Lee Arthur McGeechee, 2020 CR 04268 for simple battery, family violence. Count 1, count 2 is simple battery, count 3 is simple battery, family violence, count 4 is simple battery, and count 5 is criminal trespass. You're also before the court, sir, on a probation violation for probation revocation in a case on case number 2019 CR 08970. And this was simple battery, family violence, count 1, simple battery, count 2, criminal trespass, count 3, public drunk, count 4, and disorderly conduct, count 5. Now, you're represented by attorney Owen Lynch, who's with the law firm of Lister and Holt. Raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, you can put your hand down, sir. Also, sir, we're operating under the COVID-19 emergency, which is why we're having hearings by video. Do you agree to have your hearing by video, sir?
Yes.
Okay, thank you, sir. All right, so you're before the court on petition for revocation of probation. It says that on that you were before this court on the 23rd day of January 2020 and sentenced to 12 months probation. You have 6 months and 22 days remaining. Your sentence was not told. We did have track of you. It says that you violated criminal law by being arrested for a new offense of simple battery and criminal trespass on June 16th of 2020 in Clayton County. Says that you violated a court order by having harassing or violent contact with the victim in this case, Tarika Martin. Says that you failed to comply with counseling. You have not shown proof of enrolling in a family violence intervention program, and you failed to pay your $200 in arrears. Mr. Lynch is representing you also on the probation violation. I'll be able to speak on your behalf on that. With respect to the new charges, sir, you could enter a plea of not guilty. You could have a trial by jury or judge. The maximum penalty, if you were convicted, could be up to 12 months in jail, $1,000 fine, or both per offense. But it is my understanding that you have spoken with Mr. Lynch. Mr. Lynch has spoken with both the probation department, Mr. Austin, and also with the state. And he has informed you of what they're going to recommend to me as a sentence on your new case and as a consequence of your probation revocation, sir. Mr. Lynch, what is your client pleading to the new offenses?
Your Honor, he'll be entering pleas of guilty My understanding is that he would be pleading to, I think it's going to be count 1, 3, and 5, which would be the simple battery, family violence counts, and the criminal trespass. If Ms. Hunter can confirm that but that was my understanding. And
Actually,
then,
counts 2, 3, and 4 have been no process, so he's pleading to the 1.
1 and 5. Okay. Sorry about so yeah,
Okay,
he'd be
no
pleading
problem.
guilty.
All right, sir.
Yeah, how
So
can it
by
be
entering
simple?
a guilty plea to count 1 and count 5, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. McGeechee, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Joe, looks like Joe's muted.
Um,
I'm sorry, y'all. I was just trying to keep
that's
it-
okay. Do you understand all of these things, Mr. McGeechee?
Yes, ma'am.
Okay. All right. Factual basis, please, on the new charges.
Yes, Your Honor. So on June 16th, 2020, Clayton County Police dispatched to 9573 Brer Creek Court, Upon arrival, officers spoke with the victim, Tarika Martin. Tarika Martin stated that Lee Arthur McGeechee dragged, choked, and ripped her shirt, as well as he pushed her into their bedroom. Officers also spoke with Terrence Anderson, a witness who provided eyewitness testimony that McGeechee had been physically abusing Tarika Martin. Martin also provided, while on the scene, a shirt showing the officers that a physically ripped shirt, and upon that evidence being presented, McGeechee was placed under arrest.
All right. Is there any reason he wasn't charged with aggravated stalking since Ms. Martin was the victim in the other case, or am I mistaken?
She's fixing to get heated. It's fixing to get heated. It's a new AG too.
Your Honor, from our understanding here in the solicitor's office, it would have needed to be a little more before we could have charged the aggravated stalking in this case.
A little more what?
Well,
Am I not clear that aggravated stalking is if he has a violent or harassing violation of the court's order to stay away from someone? So I'm unclear as to why folk are reluctant to charge aggravated stalking, especially if it's violent contact or the violent contact is alleged, and especially in this case, allegedly witnessed.
well, it is our understanding it has to be more than one incident, Your Honor. It has to be repeat for the aggravated stalking. It can't just be one incident of him violating that particular part.
No. The first incident, when I set the bond condition, is the first incident. Any repeat contact with the person is aggravated stalking. Have they changed the law since I was doing this in magistrate court?
Woo! Get him, Judge.
On the new case that has come out, Your Honor, and I can present that case to you, and I can present it after court so we can discuss it and we can read it, but there is a new case regarding aggravated stalking and charging that, yes.
And Your Honor, not to comment on this case in any way or any criminal charges, but I think what Ms. Hunter is referring to is that not only does it have to be a violation, they would have to allege that it's a part of an ongoing pattern of harassing and intimidating behavior. That's not
So the first time and the second time is not a pattern.
No,
It
Your
would
Honor.
have to be, he'd have to beat her again, is what you're saying.
Your Honor, we can present, I will provide you with the
I
case.
get the case law. I've read it. The fact that the ongoing pattern, two is a pattern, is what I'm saying. And I don't understand the fact that the office doesn't see it that way. If he does it once and he's been warned to stay away from her, then he does it again. That is a pattern. It is ongoing. How many times do we have to put this woman's safety and life in danger until we can establish a pattern sufficient to charge a felony?
Well, Your Honor, I don't think that's our office's position. I think that's the case law's position.
Yeah, that's his
How many
attorney.
times does the case law say?
I understand what you're saying, but we have one order that stated for his sentencing was no violent or harassing contact. That provision is placed on the case that you entered in, no violent or harassing contact.
And he had what is alleged.
Right, so that is one instance after you provided that no violent or harassing contact. I would need more.
But the previous contact was violent and harassing. The reason I gave a no violent or harassing contact order was definitely because she asked for it. I wouldn't have done so otherwise. But the fact that you can't consider the previous incidents where we have the same charges or similar charges, that the pattern has to start after I set the condition as opposed to it being a pattern from the date the condition was set or from the incident that set the condition. I'm not meaning to fuss at you, Ms. Hunter, but
I don't feel fussed at, Your Honor. I just, I guess we're just reading the case law different. I guess we just need to get an understanding of what that really means and how we're going to move
I'd rather read the case law so that it protects somebody from being killed. So my reading of the case law is the first incident where that first person is the alleged victim of a violent and harassing event, even if the condition is set after that that says you're not to have any violent or harassing contact, you can consider as part of the pattern the first incident where there was violent and harassing contact. I don't know how many bites at the apple we have to give someone before we can establish that aggravated stalking has taken place. But this isn't a discussion for another day since you all didn't charge that. So let me know what the recommendation is.
The recommendation is 12 months to serve 6 months. The balance will be suspended so long as there is a new violation of law, and it's to run consecutive with the probation case.
Not to interrupt, my understanding is that the recommendation was concurrent.
That's
How long has he been in?
Oh, that is correct. I'm sorry. It's concurrent.
He's been in since July 23rd.
July 23rd.
No,
I'm sorry, June 23rd.
Mr. Austin, what's the probation recommendation?
To revoke the remaining balance, which is 6 months and 16 days at this time, and close the case out.
So, Mr. McGeechee, don't say anything, but I'm about to talk to you, sir. So, Mr. McGeechee, my preference in this case is that you would be charged with aggravated stalking. And the reason is I believe that there's a pattern sufficient to establish that you have violated the court's office in a violent or harassing manner against the same victim that we had your previous case about. Now, because of some reading of the case that I believe doesn't protect victims in this situation, the solicitor's office has not charged you thusly. I don't make the charging decisions. I do make the sentencing decisions. And while 6 months seems a little bit light to me in light of what's going on, I do need to advise you that even if Ms. Martin wishes to have contact with you, when you go over the line and somebody witnesses you beating her or having violent or harassing contact with her, to me, that is aggravated stalking, which means that would be a felony punishable by up to 10 years in prison, a $10,000 fine, or both. And when you're arrested on aggravated stalking, because they're fearful for the victim's life, judges set a no bond situation where you would be in jail for 3 to 4 weeks with no bond. Are we clear?
Yes, ma'am.
Okay, so you're going to spend this 6 months in jail, but you understand that you still have, now it will be a no contact condition with Ms. Martin. You understand? Violate my order again, and I will give you as much time as I possibly can, sir.
Woo! Get him, Judge.
Yes, ma'am.
And I will definitely make sure you get charged with aggravated stalking. Because let me just, I don't want you to talk, but let me just say this. If you are in a situation where you're in jail twice over the same woman, One of y'all needs to walk away. And it would probably be you, since you keep ending up in jail. If she's not smart enough to protect herself and walk away from the physical consequences, you keep ending up in jail for beating the same woman. We clear?
Yes, I'll have a question. When you say no contact, this is my wife.
No, I don't care. I don't care. I really don't care. Because you seem to not be able to follow my no violent or harassing contact. The fact that she's your wife doesn't give you the opportunity to beat on her or to violate my order. So no contact means no contact.
That means that I can't go around my wife, period?
Yes, yes, sir. Because I tried it your way before. We clear? Because now's the time to hash it out. If you don't understand what I'm saying, ask me the questions.
I mean, like, me and my wife, we were already talking about going to counseling after all of this is done.
Then you're gonna wait until the 12 months is over.
12 months?
Yep. 6 months that you're gonna be in jail and the balance of the 12-month sentence.
Okay. All right.
Oh, well, and see, by that response, I know you're gonna have contact with her. So be advised, when they bring you in again and you've had contact, that will definitely be the pattern that's necessary to meet the case law that we're talking about. Okay?
I'm just calculating.
How long it's gonna take you before you can get to her again?
Woo!
No, not how long it's going to take until all of this is over with. Like, I know
if you would stop having violent or harassing contact with her, we wouldn't have to come back to this, but you were just here in January. So it seems about every 6 months.
It's when I drink, Your Honor. That's what it was.
It's one what?
When I When I get drunk, that's when it happens. And
then that's another situation. You should stop drinking.
And like I said, me and my wife, we were talking, and like I said, when I get out, I'm not going home off the bat anyways, because I told
No, you're not going home for the remainder of the 12 months. So you can count from this day to 12 months from now, you're not going home. No contact.
I understand that.
Because if this is what happens when you drink, until you get the drinking under control, you don't need to have any contact with your wife. We clear?
Yes, Your Honor, we're clear.
All right. So I'm going to accept your plea of guilty. Let me see which ones.
Yeah, he's not going to listen.
1 and 5, I believe it is.
Yes, Your Honor.
And I'll sentence you to 12 months to serve 6 months. Balance will be suspended, but you'll have no contact with Tarika Martin. No contact. Also on the probation case, I'll revoke 6 months and 16 days, the remainder of your sentence. So upon service of the 6 months and 16 days, then you'll be released, and the balance will be suspended as long as you have no contact with Tarika Martin. Do you understand, sir?
Yes.
Your Honor,
any questions? Yes,
can I just
Mr.
ask
Lynch?
on behalf of Mr. McGeechee, I do understand that the court's ordering no contact for the remainder of the suspended sentence upon release. Although he did mention taking parenting classes, if he were to complete something of that nature, would Your Honor be willing to revisit the stay away condition?
No, because parenting is not what he needs. He needs alcohol abuse treatment, and he also needs the family violence intervention program, which I sentenced him to do the last time, which he didn't do. So no, ma'am, no, sir, that's not going to work. I'm not going to change it, because the last time I gave him the opportunity to do what I'm saying he needs, he didn't do it. He didn't enroll in the family violence intervention program. And so he had between January and June, we weren't even in COVID at that point. So he had the opportunity to enroll in the program and do what I asked him to do initially, but he did not. So a hard head makes 6 months.
Okay, Your Honor, but I also explained to my probation officer, as soon as I started the weekend jail, I got fired. I even went to Officer Austin and tried to get help in finding a job. Then once I did, I even called him, that was sometime in June or May. I called him and let him know that I didn't know how to enroll in the class because they said that they were doing it by video. Just as well as I didn't know that I could pay my probation because I didn't know the offices were closed. The only time that I've ever paid probation was coming up there and visiting him and paying my probation.
He just needs to be quiet.
So I didn't know anyway. And then I had left him emails. I've been calling. The last time I called him and I let him know that I left him an email trying to figure out what do I do as far as the weekend jail, the classes and all of that, because I didn't
All right,
know.
so sir. I got you. But I said what I said. And you had from January to do what I asked you to do. So the sentence is 6 months and 16 days on the probation matter, 6 months to serve concurrent with the new case. And on both cases, on the probation matter and on the new case, you'll have a no contact provision with Miss Tamika Martin. We clear?
Yes, ma'am.
John Bubba said he digs any deeper, he'll smell kung pao
All right,
chicken and
any
hear
questions,
Chinese music.
Mr. Lynch? Anything else?
None at this time, Your Honor.
All right, you can go back with the sheriff's office, sir.
It's not really a laughing matter, but it's not a laughing matter. But I just love that she's on top of it. And I guess the AG was like, well, the state's going, we did all we could do at this point. And she's like, no, it's not enough. But she's right. She's absolutely right. And guys, this stuff that I'm doing with Judge Tammi, this is probably 2020, I think, is when I've started streaming her live stuff. So I'm starting backwards and going forward. So we might see this guy again before it's all said and done. So put that one in your Rolodex and keep a hold of it. Okay. Miss Barbara. I got to find your thing. Miss Barbara gifted 10 memberships. You're so kind. Thank you so much. Thank you. Thank you so much. Who got a membership? I can't see it on my end. Hey, Barbara Schultz. And we got Miss Barbara's coming in to help out Miss Casey tonight with the modding. Thank you guys so much. I appreciate you all. You guys are sweet. I love y'all. Okay. So I really wanted to play that one because I thought it was so perfect for this particular stream because we are talking about domestic violence. It's a topic that I've been on this week. I've got another thing, hopefully, that I'm going to drop tomorrow on it. But let's carry on with Judge Tammi. Let's see what else she's got in her bag.
No, he's not.
Okay.
He is finishing his lunch in the jail, but
Okay.
he'll be up here shortly.
Well, I don't need him unless y'all are prepared to do a plea. Otherwise, he's going to be on the next trial calendar at the top of the trial calendar.
Yeah, that's fine.
Okay. Don't mess up his lunch. All right. Willie James Moses. That case is closed.
Incorrect.
I have a 2019 CR 09316 case.
Yes.
Excuse me, Your Honor.
Yes, sir.
I'm sorry for interrupting your court. I just came in. I was wondering, did you call Charles Hill?
No, sir.
Okay, I'm sorry. Thank you.
All right, Ms. Buchanan.
Yes, ma'am.
Hold on a second. Can we have a status on her case? All right. Charles Kennedy. Charles Kennedy. I do not have an attorney listed. Charles Kennedy.
Your Honor, he's here in the courtroom.
All right. Mr. Kennedy is charged with battery, family violence, battery, and simple battery. If he needs your assistance, you can go ahead and provide it to him.
Yeah, I'll talk to him, Your Honor.
All right. Thank you.
You're welcome.
that you may be aware of is Ms. Wells.
Yeah, Marcella Wells.
So I was unfortunately under the impression that she had already waived her prelim on the new case, which had not been done.
Okay.
I submitted a waiver for her pending state court case on which she has no bond on one of the counts.
Okay.
She is on today's calendar, of course. She's not going to be able to, like, she could resolve the license case, but the new case is not going to be able to resolve because it's not before state court, and she is held without bond on that
Okay.
matter.
And that's the new case is a felony?
No,
it's a misdemeanor, family violence, battery, cruelty to children. It looks like she has a bond set at $3,500.
that's for one of the counts. They no bonded her on the simple battery and gave her a $3,500 bond on the.
Was it 17-10-1? She has pending probation.
That's what they on the court case inquiry. It does say 17-10-1. And so she was not sure what they were referring to as far as that, but that was my understanding of why they denied the bond.
Okay, Judge. So I am ready on Mr. Alford and Mr. McClure.
And let's finish with Miss, I guess Miss Thompson was the one who has the issue that we were talking about.
Ms. Thompson is the one that Mr. Moore needs to talk to. Mr. Thompson is the one who's ready to take a plea. I just needed to tell him about the contact portion of what's going to be recommended by the state.
Okay. All right.
Yeah, it's
so
not just
this is the state of court matter of state of Georgia versus Walter McClure, 2020 CR 02678 for possession of a drug-related object. Mr. McClure is represented by the law firm of Lister and Holt. Attorney Dominique Hadley is here and representing him. And Mr. McClure, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am. I do.
All right, so Mr. McClure, you can put your hand down, sir. You're before the court and this hearing is being conducted by video and being recorded by video. Sir, do you agree to that happening and taking a plea under these conditions?
Yes, ma'am.
All right, thank you, sir. So, sir, you're charged with possession of a drug-related object. Have you spoken to Miss Hadley about your case?
Yes, ma'am.
All right. Now, you could enter a plea of not guilty. And if you did that, you could have a trial by jury or judge. The maximum penalty, if you were convicted, could be up to 12 months in jail, $1,000 fine, or both. But it is my understanding, Mr. McClure, that you have spoken with Ms. Hadley. Ms. Hadley has spoken with the state, and you understand what they're going to ask me to do as a sentence in your case by entering a plea. What's his plea going to be today, Ms. Hadley?
It would be a plea of guilty, Judge.
By entering a plea of guilty to drug-related objects, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. McClure, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, I do, ma'am.
All right. Factual basis, please, Mr. Brooks.
Yes, ma'am. On March 21st, 2020, at approximately 3 in the morning, officers with the Clayton County Police Department were doing traffic enforcement in the area of Highway 85 near Allen Drive. Officers observed a vehicle, a Chevy Tahoe, being driven with a dim license plate light. Officers ran GCIC on the vehicle and it returned that the owner of the vehicle was Mr. McClure, who had an active warrant out of Rockdale County Sheriff's Office. Officer initiated a traffic stop, identified the driver being Mr. McLaurin. During the course of the stop, did observe what he identified as a crack pipe within the vehicle. This ultimately led to an arrest. The warrant led to arrest, and he was ultimately charged with possession of drug object as well. This all occurred here in Clayton County. The state's recommendation recognizes that Mr. McClure has a hold out of Rockdale County Sheriff's Office and extensive criminal history. State's recommendation is 12 months to serve, 45 days, with the balance being suspended upon new violations of Georgia law. Additionally, as I understand that he's been in custody since March 21st, 2020.
I don't know if it's the
Okay.
world's changed so much. We
Anything,
just all
Ms.
have it on
Hadley, on
video
behalf
now.
of Mr. McClure?
We know more about what's going on in the world.
Mr. McClure, client, his accounting of the facts is that he was driving and was pulled over. There were 3 other occupants in the car. He told me that the glass pipe was not his, it didn't belong to him, and that the officers ended up searching the car 3 times before they actually discovered the cracked pipe, I guess. But there was a roach in the car, and he did admit to that. So he's willing to take responsibility for the drug-related objects today. He's had a job, and he's just like to get this handled so that he can return to society and handle the job. Additionally, with concerns with the hold in Rockdale County, there is a warrant out for his arrest, but I think in light of Corona, they've said that they don't want the hold to be on him. So, and they will be picking him up at a later date. So we'll be handling that after this plea is done.
Okay, so Mr. McClure, you've heard from the state and from Ms. Hadley. I'm going to accept your plea of guilty. I'll sentence you, sir, to 12 months to serve 45 days. Credit since the date of lockup. Your balance will be suspended as long as you have no new violations of the laws of the state of Georgia. Do you understand, sir?
Yes, ma'am.
All right, anything else? Okay, you can go back with the sheriffs. Next, Mr. Alford.
Yes, she is so nice.
Morning, Mr. Alford.
This one's interesting.
You're before the court on State of Georgia versus Edward Alford, 2020 CR 02677 for theft by shoplifting. You're represented by the law firm of Lister and Holt. Ms. Hadley is here and present. Sir, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
So, sir, you understand that these proceedings are being conducted and videotape, video recorded. Sir, do you agree to participate in this manner?
Yes, ma'am, I do, Your Honor.
All right. So, Mr. McClure, you could enter a plea of not guilty. And if you did that, sir, you could have a trial by jury or judge. The maximum penalty, if you were convicted, could be up to 12 months in jail, $1,000 fine, or both. But it is my understanding that you have spoken with Ms. Hadley. Ms. Hadley has spoken with the state. You understand what the sentence recommendation will be by entering a plea. Ms. Hadley, what is your client plea?
It's a plea of guilty, Your Honor.
By entering a plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am, I do, Your Honor.
All right. Factual basis, please.
Yes, ma'am. On March 7, 2020, officers with the Atlanta Police Department were dispatched to a shoplifting call at the Piedmont store in the airport atrium here in Clayton County. Officers made contact with the store manager, who advised that a black male wearing a green jacket, khaki pants, had stolen some hoodies and a duffel bag from the store.
That's
Officers patrolled the North Terminal area, identified the individual, green pants, green jacket, khaki pants as the defendant.
Why do these criminals always steal stupid stuff? Why can't they go in for something more? I mean, if you're going to get caught, if you're going to do the deed, go in for something high end. I don't understand it.
Mr. Edward. Officers did recover the merchandise on Mr. Edwards. It was approximately 5 sweatshirts and a duffel bag, to which the value came to about $178.14. Mr. Edwards was ultimately charged with shoplifting. This all occurred here in Clayton County. As this is a non-negotiated plea.
This one is kind of sad, though. I have to say, you guys, this one ends up being kind of sad. So just prepare yourselves. I think that this gentleman was wanted to get caught.
Mr. Edwards has an extensive criminal history. He has a hold out of DeKalb County for robbery. He has a probation hold out of Thomas County for shoplifting. In October of 2018, he had a guilty conviction out of Bibb County for shoplifting. Out of Doherty County, November of 2018, he had a shoplifting charge. Disposition is unknown. Case still may be open. Additionally, also in November of 2018, out of Doherty County, he had a criminal trespass charge. It appears the case is still open. He has a shoplifting out of Doherty County from December of 2018. That case appears to still be open as well. He has a shoplifting case out of Thomas County from February of 2019. That was a guilty conviction. He has a open shoplifting out of Dunwoody from July of 2019. As well, he has it's like a shoplifting that was reduced to theft by taking out of Fulton County for December of 2019. It also appears that he has 2 open shopliftings out of Fulton County from February the 3rd and February the 4th of this year. And looks like he was convicted of burglary in Florida in August of 2011. So the state's recommendation is 12 months to serve 150 days. The balance is suspended on not returning to the airport and no new violations of Georgia law.
All right. You said 150 days?
Yes, ma'am.
Ms. Hadley?
Yes, Your Honor. This is my client, Mr. Alford. In light of his history, I'm sure that I understand that's why the state has made the recommended sentence. Mr. Alford has an 8th grade education and he's been homeless for the last 15 years. I think that has led him to shoplift on numerous occasions in the past. However, in this instance, Mr. Alford informed me that he purposely shoplifted because he wanted to be taken to jail. He has hepatitis C, right, Mr. Alford? Hepatitis C. He is dying, and at the time he said all of his limbs were completely swollen, and he knew that if he went to Grady, they would discharge him before he was able to sober up and have his limbs.
Rolled up like sausages and everything. You know? I'm dying.
Let me speak real quick, Mr. Alford. So in this case specifically, he did go to the airport because he wanted to steal something and get caught and go to jail so that he could actually receive medical attention for an extended period of time. I can't speak to all of the other offenses. However, in this case, he is dying. They said there's nothing that they can do for his liver at this point. And he's just expressed to me that he just wants the guidance of probation and rehab and things like that. And that because of his purposeful act, he would like some form of leniency from the court. I know the court can't ignore his criminal history. However, and the state has expressed to me that he's not a good probation candidate. But in light of the fact that he does have to go to a different county to handle what seems to be a few other cases, and he's not going to be alive for much longer, the defense would just ask for a reduced sentence, maybe 2 or 3 months. The store was able to get their merchandise back in this case, and Mr. Alford has received the medical attention for his limbs to be usable.
That's sad.
Anything from the state?
Your Honor, given his extensive history in not just Georgia, but Florida, as well as looks like Pennsylvania, as well. The state's recommendation, I believe, is appropriate, given he has a number of open cases as well. If he has at least 2 prior shoplifting convictions and several open, and some of those may have been resolved and not reported to GCIC given the current climate. It may not be showing at this point, so it could very well be a felony, but I'm treating it as a misdemeanor without additional information from GCIC. But we believe the recommendation is appropriate.
All right, so Ms. Hadley, Mr. Alford, my sincerest thoughts about your condition. That is a horrible situation for anyone to find themselves in. So I do, want to let you understand that the court has concern for your condition and wishes that it were different. However, you have an extensive history that deals with essentially the same thing, which is that you take things from people. So I get that. And so my concern is that letting you out won't improve your health status. If the whole purpose was to steal to get into jail, then if you're in jail, then that's where you get medical help. If you don't have those abilities on the outside, you won't get it. So if your whole purpose was to get medical help, you're where you need to be. But the court cannot ignore the fact that you have an extensive history of stealing things. But Mr. Alford, you seem to want to say something. Go ahead, sir.
Yana, ever since my mother passed away in 2003, if you look at the repetitions of my incarceration, I sought refuge with the traditional system for food and shelter. And if you look at the months, it was cold days during the months that I did these things. I mean, like, and pick up a can of Velveeta sausages and open them and ask the store owner to call the police and tell them to take it so I wouldn't freeze to death and die out there like a sucker being homeless. But my ship has come in. God has blessed me to get my benefits cut back on. I got $1,500 on my debit card right here in the receiving room. I can make bail. My bail is only $200. I have nobody who love me. All my family is gone. And I can make bail right now. I can't. I got the money in my account. I don't have no family, nobody. Your Honor, I need to be guided by a probation officer so that, because I can't, I have an 8th grade education. I can't do this on my own. I need a probation officer to direct me in the right, to make sure I do the right thing to help me. The living conditions here is bad. The tallest sewage is coming out. I'm in the cell, I'm scared. I'll clean up behind myself so that they don't get infected with this hepatitis C. This is becoming very complicated, and my stool is white. I ain't got much longer to go. Bless me, this is one time. Give me a break, please. Please.
So, Mr. Alford, I'm sensitive to all of that. But like I said, the problem that I'm having is that you keep doing the same things over and over again. Even before, this has been your pattern. So how old are you, sir?
I'm 48 years old, Your Honor, and this is where it stops at because I want to die being a good person. If you've seen it, I cleaned the earth. I had $2,400. I spent only $500 for myself. This jacket I got in the receiving room cost $350. I paid cash for it. All the rest of the money I gave to little kids and people all over 5 Points in downtown Atlanta. Didn't have none. I gave away all my money.
Well, that's not a good idea, sir. If you're homeless, you've got to secure your home.
That's right. I'm gonna get me a place to stay and pay my rent, and that's why I need the guidance of a probation officer to show and
Okay, so let me tell you something, Mr. Alfred. Right now, a probation officer's guidance is not what we are offering, because it is, unfortunately, we are in a crisis situation. Probation has some issues with trying to take on new people and manage new cases. So we're not offering probation at this time. And unfortunately for you, I don't know that probation would be where you need to be. Probation, they're not your parents. They are people who are here to assist you in actively participating in the probation system and completing a sentence given to you by the court. But they're not here to make sure you get the doctor's appointments or to make sure that you unfortunately have sufficient housing and food and all of those things. That is not what probation is for. And it is foolhardy for you to have an illness that has been reported to the court that is terminal in some way, but you keep giving away whatever money you have to other people instead of securing your health and safety. So that's a problem, okay? So, sir, the court has heard from both parties. The court, because of the non-negotiated plea, I'm going to have to make a decision. If you are fine with the decision that I make, that's fine. If otherwise, you'll go on a trial calendar if you want to revoke your plea. But in acceptance of your guilty plea, the court is willing to sentence you to 12 months to serve 90 days, and you will get credit from the date of lockup.
Thank you very much, Your Honor. God bless you. That's more than fair.
All right, sir. Thank you. And secure yourself a home and someplace to be safe before you start giving away your money.
Yes, ma'am, Your Honor.
All right, thank you.
It's sad because there's obviously there's some mental health going on in there too if he's homeless and he doesn't
All
take
right.
his money and go find a
My
job and
understanding
a
is
place to live.
Mr. Terry Thompson was ready to take a plea, or am I incorrect?
He is, but
All right, I think we're all good. We're live streaming on YouTube. So I'm gonna go ahead and turn my YouTube down so we don't have the feedback. All right, this is the Clayton County State Court, April 14th, 10 a.m., started a little late, but 10 a.m. session of criminal arraignment and probation hearings. My understanding that we have Ms. Stinson, which is our only probation hearing.
Yes, ma'am.
All right, so
yep, that's Kimmy's man right there in the right.
Let's go ahead and
right.
handle Ms. Stinson, and that way we can get that done. I was sent her petition yesterday, so let me go ahead and get that.
And Your Honor, Ms. Gilkey also emailed this morning to advise that she entered a plea to the new charge on April 3rd.
Okay, so that was in one of the municipalities?
Judge Powers' courtroom.
Oh, okay. Oh, that's right. It was a felony.
Mm-hmm.
Put down for misdemeanor.
She asked a question?
I can't imagine what they went through in the jail system during COVID. It must have been just absolutely insane having to keep everyone separated and.
All right. Let's see.
I used to trim this stuff out. I still do. My earlier videos are better than this one because I trimmed a lot of this stuff out. But that's okay. She's going to start soon.
Okay, so Ms. Stinson, Ms. Stinson, raise your right hand for me, ma'am. Do you solemnly swear, Mr. Austin, raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true? Ms. Stinson?
Yes, ma'am.
And Mr. Austin?
I do, ma'am.
All right, so Ms. Stinson, do you understand that this is a video hearing and everything is going to be video recorded?
Yes, ma'am.
And you agree to that, ma'am?
Yes, ma'am.
Okay, so Ms. Stinson, it is my understanding that you're before the court on State of Georgia versus Michelle Stinson, 2018 CR 00810 on a petition for revocation of probation. My understanding is before you pled guilty to theft by shoplifting on the first day of November 2018. You were sentenced to 12 months on probation. You have 8 months and 4 days remaining. Your sentence was told. So it is alleged from the probation office that you had a violation of criminal law, that you were arrested for the new offense of theft by shoplifting on February 8th of 2019. My understanding is that may have already been handled by Judge Powers in Superior Court. You have a failure to report on November 6th, November 14th, December 6th, January 15th, and February 27th. You failed of 2019. You failed to complete community service. You had shown proof of having 0 hours of the 40 hours you were ordered to do. You failed to comply with counseling and theft prevention course that was ordered, and you failed to pay. You're currently $250 in arrears. Ma'am, you were given the petition. Is that what you understand?
Yes, ma'am.
All right. So, ma'am, the new offense has already been handled, is my understanding. So essentially that becomes a technical offense. Ms. Stimson, is there anything that you wish to tell me about what happened? You don't have to address the new offense, but you do have to tell me what was going on with the failures to appear for probation.
Yes, I did fail to appear. I have sent, before that, I did do 150 community hours with advanced achievement. I do have a job with them as well now. I did, like I said, 150 hours. It's a nonprofit organization where we deliver baskets and help the elderly and disabled go to appointments. I did, in fact, had an appointment with the Divergent Center for counseling. I was in a bad car accident. All my teeth got knocked out. I had to go through surgeries for my mouth. I had an appointment for February, I think it was February 17th, but I was incarcerated. I've been in jail now for 90 days as of the 12th of April. I didn't pay any of the fines because I didn't have a job, but like I said, I do now have a job. Went to court on the 3rd, and Judge Powers took the probation for the new case and probation and ran concurrent together.
Are you currently on probation with Judge Powers, or did she give you a different sentence?
She gave me probation with the one that I was on with Officer Austin to run concurrent. My new probation officer is Mrs. White. She gave me, sorry. Oh, she gave me, they gave me 100 community hours. Like I said, I've already done 150 community hours. I have changed my life around. I am taking care of my grandson. Like I said, I have changed my life around. I'm sorry that I had to come before you in this manner again, but it's been an experience. It's been an experience. Like I said, I've been incarcerated now for 90 days, and I never want to do this again in life, ever.
Okay, Mr. Austin, anything on behalf of probation?
No, ma'am. I do see that she has been incarcerated now in Clayton County since March 13th. The recommendation from probation would be 60 days to serve and close this case out.
All right. So any objections from the state?
No objection. Can you hear me?
Yeah.
Okay.
Your Honor,
Yes.
may I ask, so when Judge Powers put the two probations together, how does that work?
Well, she's already spent 90 days, is my understanding.
Yes, ma'am.
Is that your understanding, Mr. Austin?
I only show in our computer base from March 13th, unless she was somewhere else.
I was in Fayette County Jail for
Yeah.
60 days and I came here.
Okay, so now,
as of the
Mr. Brooks.
I think I was just gonna say I can check on CP8 if give me just a moment.
Okay, thank you. Can you bring me that other table?
I'm also an inmate working here as well.
All right, let me know when you have it, Mr. Brooks.
Yes, ma'am. Let's see. Looks like she was brought in custody 3/13.
Okay, so she's only been in our jail since March 13th.
Mm-hmm.
She has a 60-day recommendation. All right, so Ms. Stinson, so here's the issue. As I recall, when you came before me the first time, you were adamant that you had not been shoplifting. Oh no, you wanted to take it to trial. We were at the point of going to trial, and right before trial, Walmart appeared with their video from the store, and that's when you decided to take a plea. And as part of your attorney, Tyler Lynn worked for you, then you complained that she hadn't done a good job for you. And then you went out and got another shoplifting charge.
Oh, ma'am, that's not how it happened. I did not do that at Walmart. I didn't. I'm still adamant about that, but she scared me. And that's why I did not take it to trial. I did not do it. And I still, to this day, I did not do that.
Because as I recall, it was about baby clothes for your grandchild. It
was, no, what had happened, I had went in, I had some stuff that I was returning as well. It was for my grandbaby's baby shower. And I had a pack of Pampers that I was gonna pay for with the gift card from the stuff I was returning. And on my way to the customer service, he stopped me because he said I went out of Walmart by pulling the car into McDonald's.
How long were you in Fayette County Jail, ma'am?
For 60 days, ma'am.
Okay. And then you came here to answer the charge before Judge Tammi.
Yes, ma'am. I have not gotten it. Like I said, 150 hours. I was in an accident, a car accident, and knocked my teeth out. I have changed my life. I don't, ma'am, I've done my life around. I've changed my life around. My husband has had 2 strokes. Like I said, he's having a hard time taking care of my grandson. My mother is 86. The lady who was coming to see about her since the corona has not been there. Your Honor, please, I'm begging you to let me go home today. Please. Please.
All right, so at this time, Ms. Stinson, the court is going to revoke 30 days. I'll give you credit since the day of lockup, and then you'll be released. But I'm also going to terminate your probation upon service of the 30 days, because I don't think you're a good probation candidate. And I think at this point, with everything that's going on, that probation could not manage your case well in light of what's been happening before. But Ms. Stinson, listen to me. I know you got a lot going on, but please understand that you've had some consistencies in the charges that have come before this court. So please govern yourself accordingly. You do not want to, especially during this time of crisis, you do not want to end up back in any jail, Clayton County or anywhere else. We understand each other?
Yes, ma'am, totally. So am I going home today?
Yeah, you should have sufficient credit so that you can go home today.
So you're gonna lift the DOP?
I'm gonna what?
That how that works? The DOP gets lifted?
Yeah, I've revoked now I don't have any, listen to me carefully. I don't have anything that shows what happened before Judge Powers. If she's gonna run it concurrent with what I do, you should get out today. But if not, you could still potentially have, if it's time to serve for her. On my VOP, you'll be out today, and I'll go ahead and get that order sent over today, okay?
God bless you, ma'am. Thank you so much. You will never see me again. Never.
All right, Ms. Stinson.
Thank you.
Mr. Austin, as soon as I get my iPad back, which is being used, then I'll send the order.
Thank you all.
Or actually, I can do it I'll do it right now on my phone. And 5 and 3 are no pros.
Yes, ma'am.
All right. So, Ms. Wells, by entering a plea of guilty to counts 1, 2, and 4, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And ma'am, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis, please.
Yes, ma'am. On December the 11th, 2019, officers with the Clayton County Police Department were doing traffic enforcement in the area of Flint River Road and Taylor Road. Officers observed the vehicles run a red light, initiated a traffic stop, and identified the driver to be Miss Walker, Miss Wells Walker. Officers ran the tag on the vehicle. The tag registration return canceled. As well, when they made contact with Miss Wells Walker, they did determine that her driver's license had been suspended for no insurance conviction. Due to the suspended driver's license charge, the officers did place her in custody. This all occurred here within Clayton County. The state's recommendation is 12 months to serve 10 days. She's to be credited with time served. She's been in custody from 3/25/20, with the balance being suspended on no new violations of Georgia law. Counts 3 and 5 are being non-processed.
Okay, Mr. Lynch.
Your Honor, that was my understanding. I'd ask the court to accept the plea.
Ms. Wells, you're also here before the court on a case under the name of Marcella Walker. Is my understanding that you'll be entering a plea of not guilty to that offense. The court has set bond on the offense where you were given no bond status under magistrate court under 1710-1 because of your having previous probation or parole or a previous offense that involved violence. So this court has given you a bond of $7,500 on the offense of battery family violence where you did not have a bond. The conditions are that you will stay away from the incident location wherever this is alleged to have occurred, and also that you will have no contact with the alleged victims in the case. Do you understand, ma'am?
Ma'am, I had a question.
Sure.
Okay, I know I haven't been the best person in it for Judge Hayward, and I've been also going through a drug addiction. I was on drugs. I went on a binge and I had relapse on coke. One thing I can say though, like even before I came to jail, I did stop on my own to do that. I do also understand that Georgia, I know Clayton County do not have a rehabilitation program. Only thing they do is just sentence you to jail and then send you right back out without providing help for anybody in the state of Georgia, you know. And then like if you do try to seek help, you have to pay for it. And everybody don't have the means, you know, financial means to pay to get help. You know, I mean, we get sentenced and constantly get sentenced and then just thrown back out there in the street without getting the necessary help that we need. At the end of the day, you know, with my new charge, I have been sitting for 3 more days would make 30 days that I have been sitting in the state of Clayton County, Your Honor. I do the cruelty to children case. I mean, the bond it is heavy, you know, on me. And yeah, I have I have been missing court. I have been having a FTA. I did go to Minnesota and serve my time, but at the same time,
Why is it that all these repeat felons know all about how there's a mental health problem and nobody's addressing it, yet they don't have the common sense to stay out of jail? Is that me, or is that not jive together? Is it mental health, or is it just ignorance?
I end up catching a new charge. I'm not gonna lie about that. You know, in the process of taking care of my other charges, I end up catching a new charge in the process in the state of Minnesota. But I did go down there to handle my business because I wanted.
Okay, so Ms. Wells, I get all that. What I don't want you to do is risk jeopardizing your defense in the new cases or any other pending cases that might exist. Mr. Lynch is your attorney, and he's handling your case, and I don't want you to tell us something that you should only tell him. Do you understand? I get that. But you and I know that I know your history before this court, and that's what I have to judge when I'm making a decision about bond, is if A, you're likely to come back to court, and B, if you're likely to commit offenses while you're all out on bond. A has been answered in the negative because when I gave you a bond the last time and you were before this court, you didn't come back to court. And I understand that you may have had addiction issues, but I still know that you had the responsibility to come and appear before this court. And B, being that even when I have given you the opportunity to be out to, on pretrial bonds, you have allegedly committed other offenses, some of which have been adjudicated, and not just here, but is my understanding that there's some things pending in other places. So, ma'am, the bond is what it is, and we are in the situation that we are in. Now, I have entered and received your not guilty plea for the second case, which is State of Georgia versus Marcella Walker.
You need the case number, y'all?
No, I have it, 2020 CR 02691, and that's for the battery, family violence, battery, simple battery, family violence, simple battery, and cruelty to children. So you have a bond on that case. If you're able to make the bond, then you can get out and you can handle your case with Mr. Lynch as necessary. Otherwise, you'll be put on the court's next available trial calendar so that we can get your case handled, okay?
Okay, so what is my total bond then?
Mr. Brooks, Mr. Lynch, Ms. Brown, do you have the?
I think it's 10,500.
I believe that makes 11,000 total.
I think it's 11,000 total compared in addition to what the magistrate court did give you a bond on.
Because I think it was 3,500 for the cruelty, and now this would be 7,500 for the battery, family violence. Does that comport?
It makes sense to me.
So what are the fees though? Because you have your bond and then you have fees. So I just wanted to know what are the fees.
I'm not sure. A bonding company is going to take 12 to 15%, and that's non-refundable. So that's the fee that they charge you for posting the bond. So 12 to 15% is what a bonding company will post. Otherwise, you can do a property bond. I don't care how you make the bond. So you could do property, you could do cash. A property bond, the property is going to be held as security for the bond until such time as you've completed the offense and sentencing for the offense. So if you want to use property, that's fine. If you want to do cash, that's fine. The jail will take a small percentage and then refund the rest of it to you once you've handled these charges. Otherwise, like I said, a bonding company is going to charge you 12 to 15%.
Okay, so do you know how long it will be until my bond post?
Until what?
Until my bond post? How long will it be until the bond post?
It should be as soon as it takes me to sign the order. As soon as Mr. Lynch gives me the order, you'll have that bond. And he'll
typing it
over
now.
to me in a few minutes, especially right after the hearing.
As soon as you shut up and let them get on with their business, they can get that taken care of for you, ma'am. Hey, Barbara Schultz, a member for 11 months. You are an OG. Thank you so much. Crazy Casey says it's cold as balls outside. Girl, I know my dog looks at me like, you sure you want me to go out there? Because I could go inside. I really could pee inside. I don't have to go outside. And I'm like, no, you need to go outside.
Assume.
Yeah, I'm trying to write it as we speak.
So he'll get it to me and I'll sign it and send it right back to him.
Okay, thank you.
All right, ma'am. Thank you.
And you know, it's like when they have felonies in other areas and other states, it's like,
all right. So
Do you have a
Mr.
tentative date?
I just shake my head.
I'm sorry.
Do you have a tentative date, trial date to put?
I don't have, I wish I did, Mr.
It's
Brooks.
a tough question. I'm sorry.
No, we got to work on that. I don't know that we have clarified the whole juror situation.
I get it.
So we have dates where I am scheduled to have jury trials in May. And I can ask Miss Val to give you those dates because I know Miss Wills has posted them. But I'm not sure yet if those are valid dates that we can count on because I'm not secure in the fact that we are actually going to have jurors in the building. So that's my only hesitation in naming a date.
I understand, Your Honor. Thank you.
So Mr. Austin, we have Mr. Watkins, Mr. Burton, and Miss Billingsley. Yeah.
Yes, ma'am.
So which one do you wish to bring out first?
Yeah, the dog's one of the cats right now.
Do they have females up?
Yes,
Deputy Law?
yes, ma'am. We have Miss Billingsley here.
Okay, can we bring Miss Billingsley up?
Yes.
Thank you.
Miss Thompson.
She's not gonna make it. Miss Thompson?
Yeah, Miss Thompson, we can reset her. That's fine.
Okay, yeah, we haven't talked to her up.
Come on, Miss Billingsley.
You can send her back.
Are we resetting her till next week? Or you want?
We're resetting her, but I'm supposed to be getting a mental health eval order. So once we get that, then we'll submit that so that she can get the evaluation that she needs.
Poor dogs. They got to go outside. I tried to teach mine to pee in a litter box. They can't even pee on a pee pad. They miss it. They miss the. My little chihuahua.
Yeah. Those are male. But it's, and what's called admin is 7, but it's afternoon.
All right, so we have Ms. Billingsley. Ms. Billingsley, you're before the court on a probation revocation. State of Georgia versus Christy N. Billingsley, 2019 CR 05226. Ma'am, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. Okay, speak up for me.
Ma'am, I do.
Okay, so you can put your hand down. Ms. Billingsley, you understand that because of the emergency, we're conducting court by video, correct?
Yes, ma'am, I do.
And you wish to go forward with the video format, ma'am?
Yes, ma'am.
Okay, so Ms. Billingsley, the probation department has submitted the revocation form to the court. It says that you were before this court on the offense of simple battery on the 14th day of June 2019. You were sentenced to 12 months on probation and you have 2 months and 19 days remaining. This is, your sentence was told because we lost track of you at some point, and this is your second hearing. So the allegations are that you failed to report on November 26th of 2019, December 3rd of 2019, January 13th of 2019, I'm sorry, of 2020, February 5th of 2020, February 12th, February 24th, and March 11th of 2020. The March 11th date was the last revocation hearing. You failed to appear for that. You failed to comply with counseling. You were supposed to take an anger management program and submit proof of having done that. You failed to complete community service. You've shown proof of having completed 0 of 40 hours that were ordered by this court. So, ma'am, what's going on?
I had a hearing in November, and you removed the community service. You asked me to complete the anger management, and I have failed to do that. The last day I reported was January 13th or 14th. So,
okay, did you do the anger management?
No, ma'am.
Okay.
I didn't have the funds for it.
You did what?
I didn't have the funds required for it.
Okay. Are you working, or had you been working?
When I talked to you last, we were discussing the fact that my dad's in hospice, and I was going back and forth to Macon, and I just didn't have the money. It was my grandma and my dad. My grandma since passed. That's the last time I reported. I I talked to my probation officer in February and made her aware of that. And since then, I'm guilty of it. I mean, I did report, and I didn't complete anger management because of my job status.
Okay, so you know that you have to report if nothing else. That's the quickest way to get arrested, is to not to report, right?
Yes, ma'am.
Mr. Austin, do you have a recommendation for Ms. Billingsley?
I do, ma'am. And on the November revocation hearing, you only suspended the fines and fees.
That's I know. I didn't stop you from doing community service. I probably did tell you to focus on helping your dad, but that didn't remove the recommendation that you do community service. I just anticipated that at some point you would do it, in light, knowing that you had the remaining months to get that done.
Recommendation from probation.
The fees and fines, the money part of it, because I knew that you were struggling and did not have a consistent job at the time. Do you have a recommendation, Mr. Austin?
I do, ma'am. It'll be 60 days to serve credit from March 18, 2020, and this case will be closed.
Credit from March 18?
Yes, ma'am.
Let me see my kids.
Oh no, she's
all
worried
right.
about
So,
seeing her
Ms.
kids.
Billingsley, have you had any contact with the alleged victim in this case?
I've been back there. I have not been in trouble. I've been in jail for 33 days, and I have not seen my kids. I just want to go home.
I'm sorry?
No, ma'am, I have not. I have not been in trouble. I have not been there. I don't go that way. That was my old job at Bakery. No, ma'am, I have not. And
okay.
Hey, Louise.
Go home. I've been here 33 days. Not been able to see my kids.
All right.
Sean's fed up.
Okay, so ma'am, I'm going to, Mr. Austin has recommended 60 days. I'm going to give you 30 days and credits since the March 18th day.
Yes, ma'am.
And then after that, we'll close your case, okay?
So I can go home now. I've been here 33 days.
If that's up to the sheriff. If that's the date, since you got credit, and if it's the 30 days, then you'll be able to go home.
I know it's like, oh, I broke the law, but I haven't been able to see my children. Well, I'm turning to Judge
Anything
Tammi.
else, Mr. Austin?
Why weren't you thinking about your children when you committed the crime?
No, ma'am, not on that case.
Is she through, Your Honor?
Yes, thank you.
I want to go home and see my kid. I think this might be one of the last ones.
All right, Mr. Austin, I sent over the order for Mr.
Yes, ma'am.
For Ms. Billingsley.
Okay, thank you.
And Mr. Burton. So Mr. Burton, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, so Mr. Burton, you understand that we're conducting court by video because of the corona emergency. Do you, sir, consent to have your hearing by video?
Ma'am.
All right. So, Mr. Burton, you're before the court on a petition for revocation of probation, State of Georgia versus Edward Burton Jr., 2016 CR 02823. Sir, you were before this court for driving under the influence on the 27th day of June 2016. You were sentenced to 12 months on probation. You have 5 months and 2 days remaining. The sentence was told, and this is your third hearing. So, sir, the allegations are that you have violated probation by testing positive for cocaine on December 6th of 2016.
Good Lord.
And you failed to report from December 20th of 2016, January 4th of 2017, and January 24th of 2017 for the revocation hearing. You last reported on December 6th of 2016, and you have not been seen by probation since that date. You also have $374 in years. So, sir, where you been? What's been going on, sir?
I've been at the address I gave him. And the reason why I tested for cocaine because I dealt with a lot of drugs at the time. That's how I paid my probation. So, and I just been working and going home. I've been at the same address for all the time they've been looking. They never came.
So what you're saying is it's our fault for not coming to find you?
Ma'am?
It's our fault for not coming to find you?
I said, no, ma'am.
Okay, so why didn't you report to probation?
Because at the time I had just got a new job and I didn't want to lose everything because I was hungry. And I just didn't want to lose my job and be living back out on the street again.
Well, did you tell us you had a job and you were afraid of losing your job?
No, ma'am.
Well, sir, don't you understand that if we lose track of you and we don't know where you are, you're more likely to go to jail and lose that job than if we know that you got a new job and we know where you are. You haven't been seen by this court since 2016.
2016?
And on a very serious charge. I take DUI very seriously. Because we don't know where you are or what you're doing. We don't know whether you're out there drinking and driving again.
No, I wasn't drinking and driving no more. I learned my lesson. For that.
Well, I don't know that you learned your lesson.
She sees more people that come in because they didn't report to probation. So they're either not reporting because they're doing drugs or drinking, and they'll test because they have to, I guess they have to test when they go in. But she sees more people back for that than I think anything.
Mr. Burton, because I don't know where you are. Mr. Austin, do you have a recommendation?
I do, ma'am. 60 days to serve on this case and close the case. Credit from April the 12th, 2020.
Okay. Anything else, Mr. Burton?
No, ma'am.
All right, so the court is going to give you 60 days to serve. Credit from, what date is that again, Mr. Austin?
April 12th.
Okay. All right, and upon service of the 60 days, sir, then we'll close your case. But please understand that if you're on probation, a probated sentence before a court, or if you have any kind of court notice, then we're going to want to see you, because if I wanted to know where you were and keep track of you, I could have put you in jail. But I gave you the opportunity to be out and working and doing stuff to take care of yourself. But you got to cooperate with the court.
Yeah, so
Yes,
now he's
ma'am.
going to lose his
I'm sorry,
job.
Mr. Austin. I'm
because
trying
he
to
has 60
get
days.
these orders done as I'm talking to you. What was that credit for date again?
Yes, April 12th, 2020.
Okay, April 12th.
So now he definitely doesn't have that job because he's been in the pen or will be for 60 days straight. I don't understand it. I think Helen or Judy said, I think Judy said it earlier, it's like a way of life for some of these people, and it just doesn't make sense to me. It's like, yeah, well, I got thrown in jail. It's part of what happens, you know. What? KC says, remember, a lot of them just do stuff to go to jail. But yeah, you mean they want to be taken care of by the system? Just like that other guy, health and all that? Was his job a real job? I don't know, Helen. He'd been working and doing cocaine. I don't know. I don't know. Sounds like he's been doing a lot of. It is a different world. It's sad, but it seems to
All
be
right,
a
Mr.
repeating thing.
Austin,
for
I'm
these
sending
people.
the order to you now. Mr. Burton, you can go back with the sheriff.
Thank you, ma'am.
You're welcome.
I think we might have one more case before we call it a night.
The other one, the last
Okay,
one.
come on, sir.
He's a big guy.
Mr. Watkins, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, so Mr. Watkins, you're before the court on a petition for revocation of probation. State of Georgia versus Clay Charles Watkins. You pled guilty to criminal trespass on the 26th day of July 2019, and you were sentenced to 12 months probation. You have 7 months and 5 days remaining. This sentence was told because we lost track of you. Sir, you understand that we're having hearings by video. Do you agree to have your hearing heard by video?
Yes, ma'am.
Okay. So, sir, it's alleged that you failed to report on October 22nd, October 28th, October 31st, November 5th, and November 19th of 2019, and December 11th of 2019 for a revocation hearing. You last reported on September 30th of 2019. You failed to pay your $500 in arrears for the court charges. Sir, where you been?
Well, at the time, I kept my charge. I lost my job and my apartment and everything, so I had to go to Charlotte, North Carolina with my mother. But I was trying to find a job then too, and it just wasn't working. So I was still coming down here and checking probation, but at the time, it just got kind of hard, and I actually didn't have any funds. I was homeless and stuff like that. But in that time, I did get into school, and I tried to, fix everything, and that's why I came and turned myself in, man. I do apologize.
Sir, if you don't communicate with probation, how is it you said you were coming down here and checking in, but we haven't seen you since September of 2019?
I actually got in touch with Miss Chang, and I was telling her the situation and everything, and she was just telling me that I needed to come report. So I was trying to come report, but I was homeless, so I couldn't move around and things I needed to.
What?
Okay, what is your situation now, sir?
Well, actually, right now I'm in school. I actually have a good job now, and I actually took time out of my job to come turn myself in so I can fix everything now.
All right, Mr. Austin, you have a recommendation?
I do, ma'am. 30 days to serve, credit from March 30th of 2020, and then this case will be closed.
All right. All right, Mr. Austin, I'm sending over the Watkins. Did you get the other two orders?
Yes, ma'am. I do. I did receive one. Sorry.
All right.
This particular judge is out of Georgia, but I wonder what state. Judy, I forget what state you're in, but you should check. We should check to see if they stream any of their stuff.
All right. So, did we have any other cases at this time? We've disposed of everything?
Yes, ma'am. For probation, that's all we have.
Okay. Anything else pending for,
That's sad, though. It does seem like let me go back to the big screen. It does seem like some of them, for the winter time, to get out of the cold, they will get arrested. I don't know. What I heard one time, I was at a outdoor market, and we had a booth at an outdoor market in a little town, and one of the homeless men would come over there, and to look at him, you wouldn't think he was homeless. He was a very nice man, but he would always come over there and sit with us because he didn't have anything else to do. And he had told me that the shelters fill up really quick, and I've heard that before, but he said that what they do is you kind of have to be there. He said, I stay close so that when they start to lock the door, I'm already, I'm one of the first one in. But I can imagine that line might get pretty long in the wintertime. And it's just so sad. And all this money that we send to all these other countries, y'all are going to get me on a roll. And y'all know I don't like to be political. But we send all this money to all these other countries. And we're so worried about helping everybody outside of the United States. Yet nobody looks at what's going on inside the United States. Our homeless problems and our the way our veterans are treated. It all just kind of gets pushed to the side because this other stuff is more, what's the word I'm looking for? It just makes us look better. The US of A, we're so special. All right, I'll quit on my rant. That's my rant for the evening. It's our fault. Yeah, but no, I mean, I'm not saying that what these people do is our fault, but there are people that literally, and we did one. I just trimmed one the other day, and I'm going to probably play it this week. It was a feel-good story. There are people out there that truly do have mental health issues. Some of them are veterans, and they're living out on the street, and they get arrested so they can come back in to have a warm or semi-warm place to sleep and have food in their stomach. Now, if you put your life on the line for our country, why is it that you have to commit a crime in order to get that kind of treatment? Don't go there. Casey says, don't go there. Girl, I'm just saying, I don't know. And again, we have Casey and we have John Bubba, who both have worked in the prison system. They've both been prison officers. They know a lot more about it than I do. I would say that probably there's 5% in the system that are there for that reason, maybe. The rest of them are just damn criminals. But it's sad. It's really sad. We are not special. No, we're not special. We try to make it out like we're special. And why the hell do people want to come over here? Because we're not that special. We got people blowing each other up left and right. We got kids shooting each other in school. We got people, you can't even go to the mall anymore because people want to pull out a gun because they're getting into an argument. I'm going to lose monetization on this stream. John Bubba says, to be fair, a lot of homelessness prefer it because they have no bills or responsibilities. Yeah, I see what you're saying. But damn. Can you imagine what it's like not to know where you're going to sleep that night, every night? It just, that unsecured feeling of where will I make my bed this evening and will I be able to sleep well? I don't know. It's just, it's getting to me, guys. Plus, many homeless prefer that rock. Yeah, there are a lot of drinkers. But do they start drinking because it's cold? Or do they start drinking because they were PTSD? You know what I mean? Do they start drinking because they had mental health problems? See, there's just not enough money that's put into research and all that. There are some channels on YouTube though that I've gone down that rabbit hole where I've seen where they drive down these streets where it's homelessness is so bad. It is people don't want to watch it. People don't want to see it. But it's there. There's a lot of places. It's totally there. All right, I'm going to get off my soapbox now. Is it the same in Canada, CK? Well, the chicken or the egg theory. Yeah, I guess it is. I guess it is. And we could debate till the day is long, but it's just sad. All right, guys. Well, tomorrow I'll probably drop a video. I might not do a live tomorrow, but we're definitely doing a live on Thursday morning. So make sure that you come in here at 9 a.m. Central Time on the 18th, which is Thursday, because we're going to be doing some Daryl Brooks stuff. And maybe, just maybe, we'll see him in court. We hadn't seen old boy in a while. Wonder how he's looking. Thank you, Miss Judy. Y'all stay warm too. Ugh, Burr Rabbit. It is so cold. Y'all stay warm, stay safe, have a blessed evening, and I will talk to you very soon. Good night, all.